Hello, and welcome to eDiscovery, or electronic discovery. This is one of the hottest new topics in the whole area of digital evidence and the law. There are some reasons for that, and part of those reasons go to the amendments to the Federal Rules of Civil Procedure, which we're going to talk about in this presentation. But it's important to keep in mind that discovery is not limited to the civil side of the house. Discovery is defined as the formal procedures used by parties to a lawsuit to obtain information before trial. And it occurs in both the federal and the civil systems, in both federal civil trials and criminal trials. And by the way, all states have their own set of civil and criminal procedures. Most of them are patterned, at least, off the federal rules. Most of them have some individual changes. We can't possibly cover all the different state, civil and criminal procedure laws, so we're just going to stick to the federal ones for this presentation. But the way they're actually implemented is different, and they're implemented differently between the civil and the criminal sides because of the nature of the trials themselves. It's important to realize that criminal trials are the government going against individuals, and the government is presumed to have much more in terms of resources. Civil, on the other hand, are against two opposing parties, and so they're presumed to be a little more equal in their resources. There are actually a whole lot of different forms of discovery, some of which you're familiar with, some of which you may not be familiar with, but you probably didn't think of them in terms of discovery tools, if you will. The one that's used most commonly in civil cases is deposition, and this is oral testimony in which a witness or one of the parties to the lawsuit are required to answer questions under oath before a court reporter. These are traditionally done for virtually all witnesses in civil cases. It is occasionally done in criminal cases as well, so you may find yourself doing a deposition, typically being called by the opposing party, the party other than the one for whom you did the examination. Interrogatories. These are a formal written demand of the opposing party for information, and they're required to answer it in writing in the effect of being under oath. And so these are another form of discovery. Request for admission. Normally you'll hear it referred to as a stipulation, although technically stipulation is something that happens at trial. But what you're essentially doing is asking the other side to agree with you that a certain thing or a group of things are in fact facts, so that you no longer have to take up trial time in order to prove those facts. Request for physical examination. This is particularly done for tort injury cases, and it's also done for psychological cases as well. Request for production of documents. This is by far the most common civil form of discovery, even more common than depositions. It basically asks for everything under the sun that the opposing party might have that might help to prove what's called the serving party's interest. Similar to that is request for inspection, and this is where you're asking to look at stuff that they have in their possession as opposed to actually getting copies of it. Subpoenas are more commonly used in criminal cases than they are in civil cases, and we'll see why here in just a minute. But there are really a couple different kinds of subpoenas, even more than is shown in this outline, which, as you can see below, was gotten from a pretty useful website. A subpoena comes in two forms. There's what's called a trial subpoena, and that's actually issued by a judge, and it's typically issued after charges are brought or after the initial filings in a civil case, and require a party to bring this to show up for trial. There's also a thing called a grand jury subpoena, and they are, while issued by a judge, they are at the request of the grand jury, and these are done before trial. a version of a subpoena, both trial and grand jury subpoena, is what's called a subpoena ducis tecum, and that's the subpoena that most law enforcement officers are most familiar with. It basically says to the party, you can fulfill the responsibility of bringing these documents to the grand jury by giving them to the officer who serves this subpoena. And if they don't, then they can be held in contempt. It's a pretty powerful tool, commonly used in criminal investigations, much more so than civil cases. Criminal discovery. We don't typically think of it, we don't typically refer to it as criminal discovery, although if you actually look at the Federal Rules of Criminal Procedure, Rule 16 is in fact titled criminal discovery. It is fundamentally a duty of the government, again, because the government is the 900-pound gorilla and the defendant is the 98-pound weakling. It typically is used by the defense to ensure that they have access to all the information that the government has so that they can mount their defense. There are some limited circumstances in which the government can seek discovery from the defense. It's almost always done after formal charging because there isn't really a case there until the actual charges have been brought against the defendant. And they're covered by Rule 16 of the Federal Rules of Criminal Procedure. And it's kind of interesting that one of the things that by exception Rule 16 says that the government doesn't have to provide all of the work product and all of the background memoranda, etc., except where it pertains to expert witnesses. And so that's where the rule comes, where you're required to provide your notes and your work product as part of discovery in criminal cases. If you violate Rule 16, typically the penalty that can be issued by the judge is exclusion of that particular piece of evidence. And so it's a bad thing, but believe it or not, there are worse things, as we'll see in civil procedure. Civil discovery is, as I mentioned earlier, kind of a function of the two sides having to try to balance each other's interests. It is typically the primary source of evidence in almost all civil cases. It really provides the largest portion of the evidence used. It is typically done immediately following the initial filings. It's an opportunity to try to find out what the other side is up to and what they might have available, and it also provides you with the opportunity to get what are called protective orders, which basically keep the other side from getting rid of or altering or destroying evidence that might help you in your case. Because it's civil and because it's far more complicated and because this whole civil discovery is wound through the entire civil procedure, it has a number of rules that particularly apply. And we're going to talk about actually 5 of them, 16, 26, we're going to mention 34 briefly, and talk about Rule 37. But because discovery kind of goes through the entire process of the civil trials really are kind of stylized negotiations, part of which is held in court and a lot of it is held between the attorneys and the judge. It's much more integral to the process, and therefore the judge has a great deal of latitude of how he deals with people that aren't playing fair on civil discovery and aren't playing by the rules. The judge can assign costs to a party that withholds evidence so that they have to pay the other side for the work that it took them to discover the fact that they were in fact withholding the stuff. Evidence can be excluded from either party based upon if somebody violates one of the rules. One of the truly powerful sanctions that we don't have in the criminal side is what's called an adverse inference instruction. And what that basically says is that the judge will instruct the jury to assume that the information that was not produced would have helped the opposing party, and that whatever the opposing party says that evidence would have showed, you were to assume that was actually proved. And even worse than that, if you are really bad and really intentionally withhold evidence, the judge can actually instruct the jury to give a directed verdict. He can basically say, as a matter of law, you lose, and the other side wins. So the penalties for violating the civil discovery rules are pretty strong, and strong means costing money in the private sector. And so there is a tremendous focus now on the electronic aspects of civil discovery. And so you're going to see a lot more of that, and you can expect that forensic practitioners will be far more involved in these things. The Federal Rules for Civil Procedure, typically abbreviated FRCP, were amended in December of 2006. And they were amended for the express purpose of addressing digital evidence. One of the things that it does is it defines digital evidence as a new form of evidence. We'll see that in one of the rules here in a minute. It is going to have tremendous impact on forensic practice, both in terms of the volume of forensic practice, but also in terms of the way in which forensics is practiced. Because the Federal Rules of Civil Procedure are going to generate lots and lots of work, and because they're going to generate lots and lots of volume, the way in which it's done is going to be much more business-like, and the courts are going to recognize the difficulties in dealing with large amounts of evidence in this area of practice even before they do in the criminal side. So I think they're going to have tremendous impact. Federal Rules of Civil Procedure, Rule 16, talks about pretrial conferences, scheduling, and management, and it really talks about one of the very first steps of the actual trial, and that is to have a pretrial conference and scheduling of all of the functions that lead up to the civil trial and the management of the evidence, etc. And it requires the judges and the parties to sit down, and one of the things that it requires is they specifically address how digital evidence is going to play in this particular case and how they are going to manage that process with the two parties. Obviously, the two parties are going to come to the table with their idea of how it ought to be managed, and it's up to the judge to figure out whether to allow that or how to actually manage the two parties' expectations. One of the things that's really come to the fore in this throughout all of the amendments is this notion of inadvertent disclosure of privilege. And what that means is that because there's so much data and the data has to be turned over under discovery, there's a much more likely possibility that information that the opposing party should not have is going to end up in the opposing party's hands. And normally when parties give information to the other party, they explicitly are waiving any expectation of privilege that they have. The courts and now the federal rules recognize that that really isn't intentional, and so they make provision for ensuring that the privilege is adhered to, even if it's in the opposing party's hands. And one of the issues that has to be discussed at the pretrial conference with the judge is how privilege and waiver is going to be handled in this particular case. By the way, just last month there was a very important conference on how to make other parties abide by that privilege. The main rule in the Federal Rules of Civil Procedure is Rule 26, and that is that parties must disclose electronically stored information just as if it was a document. It did away with the old term data compilations because it was no longer important, and no longer real now that there's electronically stored information. As part of the discovery process under Rule 26, the parties are required to identify sources of electronically stored information that might be available to the other folks and the terms under which they can be searched. They also have to figure out if the information is, quote, reasonably accessible. And this is a very complex area. In fact, there's a whole bunch of law developing around that. We don't have the time, and quite frankly, I don't have the legal expertise to provide you much of a dissertation on it. But the long and the short of it is reasonably accessible doesn't mean what everybody thinks it means. Reasonably accessible means that it can be reasonably retrieved even using forensic techniques. On the other hand, it also has to recognize the cost of doing that. As an example, if you have a bunch of backup tapes, you don't have to restore every single tape or search every single tape unless you can demonstrate that the value of doing that outweighs the burden and the cost of doing that. And so this is an area that's going to be litigated pre-trial, probably very early on between the parties as to what constitutes reasonably accessible, who pays for that, and should the burden shift from one side to the other, either to show the value or the cost of that burden. And does the value of that evidence outweigh that burden? This is an area that we don't ever see in the criminal side. Rule 33 talks about the interrogatories, and it allows the parties to essentially say, look, you asked me about this, here's where that information is, and here's how you can search that information, and I'll make that available to you, and you can come do your own search. Save me the trouble of having to print it out or export all that data. It does put a burden on the responding party to make sure that the serving party can actually get to those records, that they're not in some weird format that can't be easily read. And it basically tries to streamline the process so that you don't actually have to do a humongous data dump. Look, we have this tremendous database. You can get what you need out of it by doing these queries, and we'll make those available to you. Rule 34 is actually the rule that creates this new form of evidence called electronically stored evidence. It recognizes that while there are a lot of similarities with documentary evidence and real evidence, it has some differences. Among those differences are that it's dynamic, that the information actually changes over time, and some of the storage formats of them routinely overwrite the information as new information is found, and they recognize that providing every last bit of data is not realistic and is not good business. It'll be interesting to see how this particular aspect of it impacts the criminal prosecutions, because we don't have such a rule on the criminal side, which may be good or may be bad depending on your view. It also recognizes that the volume of evidence is so large that you cannot expect 100% review of all of it, and that the media on which the data is stored is changing, as is the formats of the data themselves. And so that it instructs the courts to take a very broad interpretation of electronically stored evidence and to try to put as much under that roof as possible. And the last rule we'll talk about is Rule 37, and it doesn't add any new sanctions from what I can tell, but it provides a good faith defense for data that's altered. However, you have to read between the lines. It actually states that absent exceptional circumstances, a court may not impose sanctions under these rules on a party for failing to provide electronically stored information lost as a result of the routine, good faith operation of an electronic information system. There's already some case law that indicates that willfulness in trying to keep as little data as possible is not a good faith defense. It also demonstrates that just because you don't know how to get it back doesn't mean that the other side can't get it back. And so it takes a balancing view of this. And so that good faith exception has to be looked at very carefully. It also expects that companies with large IT staffs ought to have better control than organizations that are less technically endowed. It also has some case law that seems to indicate that oversight by corporate counsel is expected. And this is kind of interesting because it doesn't actually say that anywhere in the law, but there's already some case law that indicates that, and there's some interesting studies out there that indicate that corporate counsel are not doing a very good job at protecting their firms and handling electronic discovery. I know that that's changing because I've already been asked to provide some presentations at bar association meetings, etc., on these rules of civil procedure. Okay, well, you can take a breath now. This was a whirlwind tour of electronic discovery. We have just touched the tip of the iceberg, and there's still a lot of ice above the water, let alone a whole lot below. And this is an area that's going to be changing very rapidly in the next few years, and it'll be an interesting ride for all of us. Well, I appreciate your time and your attention in watching this presentation, and until next time, have a good day.